I'll be discussing the issue of fixed pay being given to probationers in the state of Punjab. Now, what has happened is that either in the statutory rules or in the appointment letter, there is a condition which provides that probationers, as long as they are not confirmed in service, will only be granted fixed pay. Now, this clause of fixed pay and fixed emoluments has been incorporated in the Punjab Civil Service Rules through an amendment dated 15th of January 2015 and several subsequent notifications which are in continuation. So this matter had gone to the High Court in 3 important judgments. I'll be discussing them one by one. The first case is Gurvinder Singh versus State of Punjab. This is CWP 8922 of 2017 and it's reported as 2020, Volume 1 SLR page 237. This is a division bench judgment. In this, the exact same conditions in the appointment letter were challenged as to whether they're only allowed fixed pay. So the court said that fixed pay is something which amounts to the exploitation of an employee, and this cannot be permitted because the state has to act as a model employer and not take undue benefit and economically exploit an employee who has no choice but to accept those conditions. Now, the High Court in this case relied on the Rajasthan High Court judgment of Gopal Kumawat. Interestingly, even in Rajasthan, identical conditions had been introduced in the rules, and those rules subsequently became the basis for the incorporation of such conditions in the appointment letters. Okay, so the next judgment I'll be discussing is Dr. Vishwdeep Singh versus the State of Punjab. This was CWP number 6391 of 2016 and it's reported as 2019 Volume 1 SCT 222. Now, in this case, the notification dated 15th January 2015 was challenged. Now, I'll also discuss what exactly is fixed pay and fixed emoluments. So in Rule 2.2 of the Punjab Civil Service Rules, which was incorporated through this notification dated 15th January 2015, it was held that fixed pay, or rather fixed emoluments, means only the basic pay without any grade pay, annual increments, or any other allowance except traveling allowance. Now, through the same notification, another rule was incorporated, which was Rule 4.1, which said that the period spent on probation, which earlier used to be 2 years and is now 3 years, shall not be counted towards any kind of a benefit as the time spent on such post. Now, in this case, in the case of Dr. Vishwdeep Singh, the petitioners who had approached the court were selected as medical officers general and they were working as probationers. They were merely getting 15,600 rupees because they were only entitled to the basic pay without any increment, grade pay, any other allowance except perhaps the specific allowance of 25% which is admissible to doctors. Now, in this case, what had happened was the matter went to the High Court and this notification dated 15th January 2015 was challenged. Now, firstly, the state raised very unfair arguments like estoppel, the fact that these people were aware at the time of joining that this is the pay that they'll be getting and therefore they should not be entitled to challenge it. The High Court, in my opinion, very rightly quashed this and said that there cannot be an estoppel against the law because an employee should be entitled to challenge any unfair conditions in his appointment, irrespective of whether he has accepted this. Another very important argument which again came in this case was by relying on Gurvinder Singh and the earlier Supreme Court judgments. The High Court said that payment of less than living wages, which in this case was taken as 15,600 rupees, is grossly unjustified, and the mere fact that such a person has accepted this cannot result in him losing the right to subsequently seek proper wages and proper pay. Also, the argument of economic exploitation was again discussed in this case, which was also done earlier in Gurvinder Singh. In this, also, the court held that this amounts to unconscionable terms and conditions, the rules and the appointment letters, and the petitioners who were duly selected working against sanctioned posts were duly qualified as per the recruitment rules and had participated in a selection process and come out successfully. They should not be paid such an abysmally low pay. So this is the second judgment. In this, the notification dated 15 January 2015 was quashed. Now, the third judgment is more recent. This is Ajay Kumar Singla versus the State of Punjab, CWP 17064 of 2017, decided very recently on 16th February 2023. Now, in this case, again, the earlier notification dated 15/1/2015 was challenged, along with the notification dated 22/12/2015, which was a continuation of the 15/1 notification. In this, the court relied on the earlier judgment of Dr. Vishwdeep Singh and held that even the subsequent notification dated 22nd December 2015 had reintroduced the contents of the earlier notification. The High Court noticed the judgments in Gurvinder Singh and Dr. Vishwdeep Singh and held that those judgments were applicable, and therefore the subsequent notification was also struck down. Now, interestingly, what has happened is that the state of Punjab has taken all these matters, Gurvinder Singh and Dr. Vishwdeep Singh, in appeal to the Supreme Court. Now, the Supreme Court has stayed the judgments of the High Court. So, the argument raised by the state was that the High Court should not even hear this case because of the stay granted by the Supreme Court in the earlier case. This was categorically rejected by the High Court. It noticed the law and several important Supreme Court judgments interpreting this issue, which held that the mere grant of stay or the issuance of notice by the Supreme Court will not result in the judgment of the High Court being wiped away. The judgment of the High Court will still remain there, but its operation will merely be temporarily suspended. So I think, therefore, in light of this, the action of the state of Punjab, in my personal opinion, even in the subsequent notification dated 17th July 2020, is again grossly unfair. I think that the state of Punjab should not have introduced a notification again on the very same lines and specifically reiterating the notifications which have already been struck down by the High Court, which is 15 January 2015 and 22nd December 2015. Thirdly, and very importantly, in this latest judgment, the High Court held that the benefits due to the employees will be applicable and they are liable to be granted from the very date of appointment of such employees. So therefore, it is not even a case where the areas shall be restricted, because once the notifications are struck down by the High Court, then the legal consequence is that the areas and the fixation and all other benefits which are due will have to be granted from the original date of appointment of the employee. Another judgment I'll discuss, though that's not on this exact issue, but I think is a very important judgment. This was the judgment of Mohinder Singh. In fact, this is Mohinder Singh versus the state of Haryana. This is CWP 22516 of 2012. Now, in this case, what had happened was that the petitioners in the case were working as drivers and conductors in Haryana roadways. As per an amendment which was introduced in their rules, what happened was that persons were initially to be only appointed on a contract basis where they would be paid a fixed salary, which was much, much lower than what was being paid to the regular employees. So after about 2 to 3 years of service, only then would the persons who were appointed on such contract basis be entitled to the salary which was being granted to regular employees. So what happened was a writ petition was filed challenging the validity of this amendment. Now the High Court again noticed in this judgment, and these are all division bench judgments, the High Court noted that since these persons were qualified and appointed through a proper recruitment process against sanctioned posts, and most importantly, the High Court invoked the doctrine of equal pay for equal work, which is that these persons were performing the same duties that were being performed by regular employees. There was absolutely no difference, and therefore this kind of a notification wherein they are initially only being paid like daily wages or paid as fixed salary, which is much lower, should not be done, and they should be treated at par with regular employees for the purposes of their pay. Another important thing was the contention of the state. Very interestingly, the state of Haryana in this case was that they wanted to only recruit the best employees, and therefore they wanted to initially recruit all such drivers and conductors on the contract basis, and then thereafter see which ones they will eventually give regular appointments and regular pay scales to. The High Courts held that this is no excuse, because the quality of their work and the objective of recruiting the best available persons could not be achieved by putting them initially on lower scales and only after 3 years giving them proper scales. Interestingly, the court also held that in this case again, that the issue of delay is immaterial if you challenge a rule in a matter involving pay scale. Even otherwise, if an employee seeks the correct fixation of his pay, there is no issue of delay, because the full bench of the Punjab and Haryana High Court says that this gives rise to a continuing cause of action. So this principle was reiterated, and it was held that once you challenge the rules, then merely the fact that you are challenging them late or you are late in approaching the court is immaterial. The state of Haryana challenged the judgment of the Punjab and Haryana High Court in the Supreme Court. The only issue before the Supreme Court was relating to the date from which the areas will be payable, because all other points were ultimately dropped by the state of Haryana before the Supreme Court. So the judgment of the High Court in this case was upheld on first principles of law. Thank you.